so-called upsets, and people will say,
Thompson.
Out of 5. Here's Garland. Banks it. Yes!
Yeah, if you had LaSalle in your Sweet 16, you're a liar. Anyway, the point is, it's a great time. Yeah, again, you don't even have to be a huge fan. You probably couldn't even find half these schools in the map, but you care about the games. That's what makes this tournament so exciting and so popular. Florida Gulf Coast University, yeah, right, and LaSalle, a 15 and a 13 seed respectively. They had to win, in fact, the play-in game, LaSalle, and yet they're in the Sweet 16. And be honest, you're probably going to watch the next game. I am. But it's not just a tournament where the colleges are making the big bucks here. Regular season games, lucrative. Look at the ACC, one of the best conferences when it comes to hoops here. The conference, home to powerhouses like Duke, UNC, etc. They have their own TV deal worth nearly $2 billion over a 12-year period. But the NCAA tournament is more than just one of the biggest sporting events of the year. Big business. How big, you ask? Well, the current TV deal, just for the tournament with CBS and Turner Broadcasting, it nets the College Athletic Associations $11 billion over a 14-year period of this contract. But not everybody profits from this. The student athletes at the center of those sales don't see a dime, and that includes former UCLA star Ed O'Bannon. O'Bannon, he's at the center of a massive class action suit against the NCAA that seeks to cut the players a slice of the cash generated by the TV broadcast, video games, it's important, we'll get into that, as well as the merchandising. It claims that the NCAA in violation of antitrust laws, allowing the names and likenesses of players to be used without their permission. Next hearing for this case is set for June. I want to bring in our guests, and our panel will jump in too. For more on what this suit could mean here, we're joined by Robert Bowen, professor of sports management and sports law at NYU. Robert, good talking to you again.
Thank you for having me back on, Richard. It's a pleasure.
You know, we get into sometimes the debate about, hey, wait a minute, a kid, and I understand both sides of the argument. He's getting a free ride or she's getting a free ride. And at the end of the day, maybe the schools make money here, but there's a trade-off of sorts. This case is a lot tougher, and you can explain it because Ed O'Bannon says, time out. I go into a store, I see a video game with my likeness after I graduated here, and they can use this in perpetuity. They can sell my jersey for as long as they want. They can sell video, whatever, as long as they want. And I don't see a single red cent. It's going to be tough for the NCAA to say, well, that's because you're a student. This stuff lasts after these guys have left campus for the rest of their lives.
You're exactly right. And there is no moral high ground when you're asserting the educational value of video games either. Essentially, that's exactly what happened in the O'Bannon case. O'Bannon's image and likeness was used in a video game long after he had turned pro, long after he had a right to exploit his own image that UCLA no longer had. And I think there's a lot less question, or at least a much lesser legal question, as to whether a school could use a player's likeness and image while they're playing there. But the answer is, how long do they have that right, especially when those players turn pro and begin to have that as part of the valuable part of their parcel of their identity that they seek to exploit. So it's a really good case. It's got another add-on element to it now that the O'Bannon plaintiffs have taken a little bit farther. They're actually saying that the colleges have conspired to set the value of player wages and compensation in the college ranks at zero, basically trying to throw over the entire apple cart of college athletics. So this could be a pretty broadly reaching suit. On some level, if you like college sports and like the structures, it may be no less upsetting to the apple cart of the business than the gay marriage suits pending in front of the Supreme Court right now, or the abortion suits you just talked about.
You know, for me, I'll be willing to put blinders on and say it's a trade-off for the kids. They get a degree here. We both know, they can revoke your scholarship at any time. You want to transfer, you got to wait a year. A coach can go wherever he wants. I don't understand how the NCAA wins this thing, and if they set precedent, there'll be a huge consequence, won't they, Robert? This isn't college football. College basketball makes money, but not anything like football. This could, in many ways, cripple the NCAA. This will have huge ramifications if they lose, right?
This could have enormous ramification if they lose, and because it's an antitrust lawsuit, the NCAA as a college structure doesn't have a lot of immunity. The pro sports leagues have broad antitrust immunity. that comes from Congress and the Sports Broadcasting Act, comes from their collective bargaining agreements where they've negotiated over these rights. The college ranks don't have that same antitrust capability, and this lawsuit's been joined by legends going back as far as Bill Russell. So this is a very, very interesting lawsuit, and it's one that the NCAA really probably has a difficult time defending. The NCAA has been a victim of a number of serious defeats in lawsuits involving antitrust claims against them in recent years, and they've been pretty aggressive in settling some of the ones, most recently the NIT case. But this is one that's going to be tough for the NCAA to defend. And again, it's that continued use element, the idea that a player once played and they get to have their image used for long periods of time and in ways long after they're done.
Yeah, and you know, Robert, thank you. And between the concussion issue for the NFL and I think this one, these are two cases people ought to keep their eyes on. Robert Boland, thank you so much. Guys, Andrew, you want to jump in because I'm conflicted in what I hope it turns out, but I don't find an argument on how the NCAA, has the moral high ground on this.
I'm actually not conflicted at all because these players are risking their
Burn
future potential earnings. I mean,
Yeah.
if you go out and you get injured as a college player, you're pretty screwed for all of the money that you're hoping to get if you're going to turn pro. I had another question, which is,
well,
does
they
this
do get an education, though.
Well,
I mean, that's something.
Free of charge, and I think that's
It's not
important.
a minor league farm team, theoretically, it's a college.
I don't think the equation is totally balanced out, but if the players win this suit, what about high schools? Because there are lots of high schools that are getting big money to be on TV for their football and basketball.
How do you want this to end?
I think at the end of the day, these guys are getting a free education, a full ride, and I think the issue is, I agree, the NCAA, they can't win on the moral high ground. Simply remove names, remove numbers, and keep it moving. I think at the end of the day, Ed O'Bannon was not.
Mark.
Listen, millionaires battling millionaires, nobody wins.
Yeah, exactly.
With that.
Sound like
O'Banion's
the end.
everybody.
Brandon,
No,
Mark,
O'Banion's
Andrew,
a car
thank you,
salesman.
everybody. I'll see you here tomorrow night at 6.